um, got it. That really brings to light some of these important facts of the case that could otherwise remain unknown by the immigration officer. Sorry, for some reason, there we go. So the objectives of the humanitarian and compassionate sort of framework is again to institute this idea of discretion. So leaving decision makers with the ability to exercise their own authority and their discretion in the context of an application. Can we actually get rid of this? Sorry, I just have to get rid of this message here. Right. So HNC, again, permits the immigration officer's discretionary authority to overrule the legal authority enshrined in IRPA. And as we mentioned, it is consistent and complementary to the objectives of our Act. And it allows the decision maker to exercise flexibility in special circumstances. And once again, it's not simply an alternative means to applying for permanent resident status in Canada. So it's not considered to be an immigration program. It's considered to be sort of a framework and a way that you establish a set of circumstances for the immigration officer to consider your case and give it special treatment as a way to overcome the barriers that exist in the Act. And so I'll pass it over to Lulwah, and Lulwah, perhaps you can discuss again in more detail the HNC assessment and what constitutes or warrants relief, and we can certainly begin from that aspect.
Thank you, Scott. Okay, so Scott laid the foundation for the HNC, but I will dive a bit detailed to talk about what constitutes an assessment of an HNC. So what warrants relief? Officers making the humanitarian and compassionate determination must consider and weigh all relevant facts and factors before them. So as you mentioned, Scott, you were referring to IRPA and IRPA, but you know, in Canada, the case law really they take form over the IRPA. So it's important to, you know, like in the cases for HNC, Kanthasamy and Baker, it started out with Baker, but later on it's transformed into Kanthasamy that I highlighted the individual HNC factors that should not be considered in isolation. They are considered part of a global assessment of the relevant factors. Best interest of a child is also very effective. Scott, do you mind, or do you want to share the screen with me?
Yeah, I can flip through the slides if you like. You just tell me when to flip. And I think
Okay.
you made a really important point about case law. And can you maybe expand a little bit on how case law and the Act kind of work together? Because you mentioned two really important cases, Kanthasamy and Baker. And perhaps can you just sort of signal how the case law sort of works with IRPA?
Okay, so it's a bit tricky because IRPA and the regulations they work hand in hand with the case law. Ultimately, the translation, if you want, an interpretation of the cases will only be found in cases where a judge will interpret the details of the case step by step and provide further information for the users, and that's where you see these cases. Before, we used to rely on Baker versus Canada. I know we're going a bit more technical, but it's important to understand the background of the cases because it's very difficult. It's not like you say, oh, I want to apply based on humanitarian and you go through. It's based on case law. So as legal professionals, we're always updating ourselves with all this information. And
Sorry,
these two.
Lulwah, can I jump in and request that you bring that part in Arabic?
Okay, you want me to speak in Arabic?
Yeah, just that part because
Okay.
I think it needs more
Okay.
explanation. Thank you.
Yeah.
Okay, I'll try my best. So
Yeah, but
case
you still
law.
can use all the English terms which are to describe in Arabic, I guess.
Okay, I mean I'll try my best. So what أنا اللي عم بقوله إنه كل الكيسز اللي بالمحكمة أوكي الكيسز تلحق الكيسز الهيرارchy and I think we have one of the slides the hierarchy of the cases. So كل ما علي القرار بالمحكمة كل ما صار binding أكثر على الحكومة. So that's the idea.
And providing some
واضح؟
guidance and direction to decision makers, right? So these cases really provide sort of like precedents, right? Would you say
Yeah.
precedents, Lulu? Yeah.
Yeah.
I
Yeah.
I can do some of the translation for that part. الأستاذة لولوى بتقول إنه في قضايا بتستخدم كريفرنس، يعني بيرجعوا لها الأوفيسرز أو بيشيروا لها الإميجريشن كونسلتنتس أو المحامين في القضايا بتاعت HSC. زي في قضية مشهورة اللي هي بدت منها الديسيجنز أو القرارات بتاعت المحكمة تتغير، اللي هي القضية بتاعت بيكر دي. كان فيها الحاجة الأساسية اللي بنى عليها القاضي القرار هي best interest of the child. بيشوفوا لو في أي طفل involved في القضية دي بيشوفوا مصلحته وين. مصلحة الطفل هي الأساسية في بناء القرار بتاعت HSC. الطفل ده ممكن يبقى الchild نفسه، ممكن يبقى ابن الزول الرافع القضية. فالكيس لوز دي بتساعد في بناء القضية بتاعتك في ال HNC. يعني لما ترجعوا لقرارات قديمة أخذت المحكمة في ال HNC ويورفرنس ترجعوا لها في الإكسبلانيشن ليترز حقتكم، بتساعد كتير. فهي combination case laws، القضايا السابقة، الإيربا القانون بتاع الإيربا والجايد لاينز بتاعت الأوفيسرز.
Okay, and to add الأوفيسر مش حيرفض طلب عارفين إنه هيدا الكيس انسمع بالمحكمة. So it would be very stupid of them. So مشان هيك you have to make sure that your cases is exactly relevant to the case that you want to argue. You know, do you want to interpret this?
يعني القضية اللي انتوا حترجعوا لها لازم تكون عندها نفس التفاصيل أو قريبة للتفاصيل حقتكم، على أساس إنه الأوفيسر لما انتوا يرفرنس الكيس ده له حيشوف إنه at the end even if he rejected the case now لما تمشي للكورت it's going to be appealed and accepted، لأنه يعني هي قضية مرت بالمحكمة قبل كده فبقت معروفة الديسيجنز فيها حتكون شنو.
Yeah.
Yeah.
Well, I think you want to be careful about saying that it's going to be accepted. I think that in some cases, you know, if the immigration officer as a decision maker doesn't follow the proper protocol, so even if the decision is not in agreement with the applicant, but the officer followed a very logical evaluation of the case, there may not be grounds for appeal. So that's an important consideration, that not every request for an appeal actually goes through to a determination stage.
Yeah, and that's called procedural fairness. You know, like when I came to this reasoning, did I follow A, B, C, D, or did I skip C and went to E? That means that you did not hear the specifics of the case. That's why it's a global assessment of all the factors. So, for example, if you're talking about a child, and by the way, it doesn't have to be your child, it could be someone impacted by you not being in Canada. So in this situation, you would have to, but you have to provide a lot of information on this issue.
Yeah, and the real value of case law is that you're providing previous decisions. You're giving those previous decisions to the immigration officer to allow that immigration officer to make a similar decision in your case. You're basically allowing that officer to arrive at a positive decision, drawing on facts from cases that are similar to the circumstances that you're presenting in your own case. So it's almost like you're giving that officer a roadmap to getting to a positive outcome or a positive decision in your application. Would you say that's fair way of framing the case law, Lulwah?
Yeah, I would absolutely, for sure, agree with that.
How do you spell this case law, and where can somebody find that other reference?
We can actually
Okay.
add that at the end. I mean, we can add it maybe in the chat box, but there is a body
Yeah.
of case law available on Canly. So canlii.org will give you access to the body, the corpus of case law.
Which I believe we have some more details on these cases. But you just Google kindly, and in the hearing of the case, you just put Kanthasamy and read it and familiarize yourself with it if you want to, make reference to it in your application. But
And
it's very important.
is it also important? I mean, we note here best interests of the child directly affected. And I think you made a very important point, Lulwah, and I think we want to elaborate a bit on this, is that the child doesn't necessarily have to be yours. In some cases, we do have a like a single female over the age of 22 who is, a family member, right? She's a daughter, and she may also be like an aunt to a child that's being resettled in Canada from Sudan, and there may be a very close relationship between her and her nephew or a younger sibling, for example, who does fall under the age of 22. So I guess when we talk about best interest of a child, how would that child sort of be related to someone who is like 25 years old and sort of stranded in Sudan when her parents are in Canada?
Yeah, and what kind of evidence can you provide? So,
Yeah.
for example, if it's your cousin or brother who's over the age of 22, then what can you provide? I mean, first of all, you have to think of, I mean, honestly, HNC, there's no right or wrong factors. That's why we referenced a lot of the case law. There's no formalities. For example, as a refugee, even refugee is a bit kind of all over the place. If you want to apply under the skilled worker, for example, you have to meet language, you have to meet experience, you have to meet these certain points. But with HNC, there's nothing like that. You have to convince the officer who is not in front of you. That's how I always tell my clients, they're not in front of me, and they're reading all this bunch of documents and trying to familiarize yourself with your case. So it's important to start, in my opinion, with the story of the person applying and their family members and why they believe HNC is relevant to them. So it kind of supersedes the situation where they are in court answering questions, because that's not the case. It's an administrative process.
Yeah. And I think as part of that process, we've highlighted a few important aspects to how the case is presented. So the first thing you want to draw attention to is in the application what exemptions you're actually requesting. So you have to find the section of the act or the regulations that you're trying to overcome. And so, for example, if it's section 1, subsection 3 of the regulations, which talk about the definition of a family member, you have to consult that definition, and you have to understand what that definition says in the first place and make it clear that that's the exemption that you're requesting to overcome. Right, Lulwah?
Yeah, exactly. So, okay, so someone's asking how to raise their hand in reactions. And in reactions, you just click on it, and then you can clap, you can raise your question, or you can or raise hand. That's what you do, okay?
We like claps too. If you want to clap as a
Yeah.
Also, for those asking, Sama has just put the website for the case study. You can find it there.
Oh, the canly.org? Is that
Yeah.
what you mean? Okay, great. Yeah.
Okay, so someone's asking, so we should tell our story about the conflict in Sudan and how that impact our lives in the explanation letter? Yes, of course. I mean, don't assume that they know all the details. I mean, they should, but not all the time. So, there's so many wars going around all over the world, and you know, I wouldn't expect all the officers to know all the details. You think it doesn't make sense, but I assume they know nothing. And so everything in the application explains the process and why this person is the person who wants to apply, why it's important that they're here.
And in terms of like providing details and showing that those details are sufficient and compelling, it's not going to be enough to simply write a narrative. The narrative is really important, of course. Providing documentary evidence, as much evidence as you can support. So when you're claiming something in a letter, try to identify aspects that you're able to prove, right? If you're able to provide documentary evidence for the details you are describing, that's going to make the case a lot more impactful.
Yeah. And it's the impact. Like if you, after you finish, Iman, I see your hand up. I'll get to you. So if after you submit your arguments, which you should do at the beginning of the we call it submission. So whatever you want to call it, you want to say, I want to apply for Lulwah for permanent residents to come to Canada under with the exemption of this and this and this. And by the way, there, if you look at HNC eligibility, I believe somewhere here, if we don't have it in the slides, we'll share with you. And you just ask, I want to ask for an exemption for these categories. Medical inadmissibility can be one of them, and this could lead to further in situations where you need you need sorry, I'm distracted. You cannot yeah, okay, I'm not gonna get distracted. So you have a chance to resubmit the application. Yes, Imad.
يا بس عايز اوضح يا اخوانا الحسي الكلام مركز في الاتش ان سي كيسز عن الابلكيشن، الاسئله في الابلكيشن والاخطاء في الابلكيشن خلوها للنهايه، ما تكتبوا اي سؤال يخص الابلكيشن والفورمات. حاليا التركيز في الاتش ان سي اللي هم الموضوع الحلقه يعني. خلينا نخلص من ده، في النهايه بنجاوب لكم عن الاسئله يعني.
Okay, thank you, Imad. Okay, Iman, unless your question has to do with HNC, can you leave it till the end?
So some of the things that we've sort of been covering so far, I think one of the highlights is that an HNC assessment is a case-by-case basis. There isn't a standard formula for officers to approach an HNC sort of framework. Instead, it's really based on the evidence and the details that the applicant puts in the application, in the supporting documents that accompany an application. And so those applications are assessed on a case-by-case basis. And some of the factors, and you may want to elaborate on some of these, Lulwah, but some of the factors would be how settled the person is in Canada. And so that point really goes to the question of cost versus risk, or sorry, benefit versus risk. What is the benefit to allowing this person admission into Canada versus what are the risks in not permitting this person entry into Canada? So that's in one of the first factors that could be assessed in a case-by-case basis. Secondly, and as it relates to our topic today, the general family ties to Canada. Is there a compelling relationship to a Canadian citizen or a permanent resident that could strengthen that claim to humanitarian and compassionate considerations? As we've mentioned already, the best interests of any children involved, and not necessarily the applicant's own children, but children that may be affected by the presence or the absence of the person who is the subject of a humanitarian and compassionate claim. And then finally, and we'll go into more details about this, is what could happen to the person if the request is not granted. So again, describing, and as Lulwah mentioned, you can't assume the immigration officer knows the full context of what's happening in Sudan, even though we think that the program officers that are going to be treating these applications will have a little bit more advanced contextual knowledge of the situation, but you can never assume that they know everything. And so what would happen if the application for agency was refused? What are the outcomes? And what are those outcomes based on? Is there a pattern of abuse of women over the age of 22? Certainly there are patterns of abuse, of torture, of violation, of kidnapping, murder. Again, pointing to perhaps some of the stories that are documented in the media as well would be a really effective technique in a submission to again illustrate, demonstrate what would happen if the application would be refused.
Yes, exactly. It's all about documentation and proving your point. How do you prove your point? If someone is let's say, physically has a disability, how do you prove it? If there's a mental disability, how do you prove it? I can say anything about my client, but how do you prove it from a third party independent point of view? So, maybe this person, they went to a psychiatric person and they gave them some information. But I have to go back, I guess. This is applying for HNC from inside Canada. Okay, there's two applications. One is for outside Canada, one is for inside Canada. If you're lucky enough to say that your family members are inside Canada, there's a separate application form that you do. And approval rates are, they're not easy to approve, but it's not the same as someone who's outside Canada. And again, we go back to ERPR and the Act, Section 25, Sub 1. It says someone who's outside Canada may be considered for HNC, and someone who's inside Canada has to be. So, you see may and should. Outside Canada, the officer may look at the application in an HNC factor, but this person has to be here. So what I'm trying to say is the onus is on you to prove your case, okay? There's no one else but you. You're submitting the application on behalf of your client to prove the case. So how do you prove it? Again, there's no application, there's no standard application. HNC requests from temporary residents are not considered. You cannot have more than one HNC. We will not risk factors such as persecution. You cannot use, I've seen many cases, they've used the Refugee Protection Division argument for an HNC application. It's definitely going to be refused.
Can you elaborate on that a little bit? Because what's the difference between somebody who's outside Canada and, you might have an immigration officer in Cairo saying, okay, no, this person should apply as a convention refugee. They should seek refugee protection with the UN, and then, submit an application for a refugee determination versus an HNC application. Can you just sort of describe how those two things are different, Lulwah?
Yeah, for sure. So one other alternative situation for an individual in Sudan, if they make it outside Sudan, you as an association, if you you can become, I don't know if you're aware of something called private sponsorship of refugees. You can sponsor those refugees without the need for any refugee status document. But to do that, you have to be affiliated with a sponsorship agreement holder so they can deal with you as a constituent group. It's a bit, can someone translate? Because I know it's not easy to understand this, but this way you can, they can be assessed under the risk of persecution to their life. If that's not the case, then they have to argue. So for example, for a girl, there's a lot of questions between girls and boys. If a boy, he's caught and he's wants to go into military, and if he refuses, he's killed. That is a risk persecution to risk to life. But I would say you can use this even though he's in Sudan as an argument, because, you know, aside from this, there's no way that this person can make it here. And a girl also, you know, there's ways that you can argue, you know, if she stays in Sudan, you know, what will happen to her from you know, stuff that they do to girls in Sudan that is deemed not acceptable by the Canadian government. So I mean, I'm trying to so who's doing the translation?
Samah, can you please help out here?
Yes, Lulwah.
Okay, so I just want you to explain to them, like, if they cannot if they cannot apply under humanitarian, that they can you as an association can connect yourself with a sponsorship agreement holder, and you can sponsor them as long as they're outside Sudan.
اوكي. فلولو بتقول انه غير ال HNC، يعني الناس ما تلخبط بين الاسباب اللي انت بتستخدمها لل HNC بالاسباب اللي انت بتستخدمها لما انت تطلب ريفيجي، ان هي ان انت معرض للخطر، معرض انه تتقتل لو رفضت ان انت تشارك في الجيش، او للحاجات للاسباب اللي انت بتقدم بها ريفيجي. الاسباب اللي انت ممكن تقدم بها ريفيجي ممكن تمشي تبع برامج اللجوء، زي البرامج الهجرة الكنسية اللي هي بتكون تابعة لمنظمات بتنظم الريسيتلمنت بروسس. بعد كده دي ما محتاجة ان انت تابلاي ل HNC. فلازم يكونوا الاسباب اللي انت بتخطها كاسباب لل HNC ما هي نفس اسباب الريفيجي ستاتس. Is that right, Lulwah? Did I?
Yeah, you got it. Thank you. Okay. So it's important for HNC to focus on not persecution, on compelling reasons, and we'll give you some examples of compelling reasons that the officer can accept under HNC, and you will have to ask for the reasons. You will have to ask for the exemption, whether it's financial, whether it's medical. You know, to include them in the application.
In the context of this temporary public policy, there already are exemptions to certain provisions of the Act and the regulations. So, for example, one of the exemptions is the requirement to have a passport. And so applicants are not required to have a valid passport when they apply for this temporary public policy, the PR public policy. So that would be an example of a humanitarian and compassionate way of overcoming one of the acts or the regulations in IRPA. And another one is the financial requirements. As you know, for the principal applicant, not the anchor, but the principal applicant, there is no requirement to show proof of financial resources. And so that's another way that the humanitarian and compassionate context overcomes a requirement that's found in the Act and the regulations. And as you can see from the fourth bullet point here, it says here that you cannot apply for an HNC claim if you have a pending refugee claim. So if you remember, we had a question with IRCC a few days ago where, you know, people who fled Sudan, they've gone to Uganda, they've gone to Egypt, they've gone to other countries. It's expected that they will file a refugee claim. And that will be the natural course of events. And if you do file a refugee claim, it doesn't actually prevent you from applying for PR under the temporary public policy, because you're not yet approved as a convention refugee. It's certainly expected that you apply for refugee status, but until you're actually processed as one and identified as a refugee, because at that point, of course, you're no longer eligible for the public policy because you have an accepted refugee claim. And so it's important to know that even if your family member has gone and made an application to be identified as a convention refugee, it does allow them to continue with this public policy. They're not excluded from the policy.
But even this, as a convention refugee, it's the same idea. There's no one in front of you, so your argument it's administrative. So it's not like you're in court and you can defend your case and argue your case. So everything is administrative. It's in the documentation package. And another caution I would, caution everyone: don't just stick to the minimum requirements on HNC. Put yourself in the shoes of the officer, and see what additional information you will need. Not to harm your case, but to make the case more strong.
This is some of the common errors that we've identified. So as you've already mentioned, don't rely on the minimum requirements. Again, being on welfare is a major red flag. This is for inside Canada. Again, where some of these points relate to cases that are inside Canada. And BIOC, the best interests of a child, is a major factor, but it's not everything. It is one of the principal factors in assessment. But of course, there are other factors, and we'll get to some of the other factors, including, hardship, access to medical treatment, other things like that. But did you want to sort of elaborate, Lulwah, on some of the common errors in a submission of HNC from the perspective of like a client?
Yeah. So, like, what do you consider a compelling case? I guess that's everyone's weakness. How can my case be considered compelling? I want to bring in my brother, my sister, my family members. For overseas HNCs, because in Canada, and Samah, I'm going to need you to translate. So in Canada, there's a separate application for HNC. For outside Canada, this accompanies an argument for an HNC. So, for example, you're applying to sponsor your mother or father, and there's a click in IMM 1344 which says, if you're found ineligible, I'll return your fees and I'll close the application. That's an idea of something that you should not do, because whether this is basically a way for people to say that my application is not considered under HNC. Yeah, and
I'm just going to open the form so we understand exactly what we're talking about. Yeah.
لولوة بتقول إنه ال HNC فيه نوعين. فيه إن أنت بتقدم HNC from within Canada، من جوا كندا ومن برا كندا. requirements تحت الاثنين مختلفة. من جوا كندا نوعا ما الأسهل كبروسيس، وكأنه أنت تثبت فيه ال best interest of the child من إن أنت تثبته من الابليكيشن اللي برا كندا. هم حيورونا حسي في الفورم، في فورم مخصوص الحاجة دي. بيسألك إذا أنت إذا لقينا الابليكيشن بتاعك is not eligible, will return back. They give you the option, right, Lulwah, whether to return the fees to process or not.
Yeah.
Yes.
I'm trying to open the form right now. It's taking forever. Just give me
You have to download it, Scott, and then right click.
Yeah, I know. Yeah. I have this feature where if you sort of highlight this, but I think I will download it anyway. But yeah, if you sort of highlight it, it'll open up the form.
Yeah.
A lot of you may actually, if you are opening PDF documents, this is a teachable moment. If you are often you encounter this message when you're looking to open IMM forms, this means that you actually have to save the form to a folder and then reopen that form once it's been saved in the destination. So I'm clearly...
But even if you want to reopen it, you have to right click.
Yeah.
Open. Yeah.
Yeah, I don't actually have a right click button on my iMac mouse.
Oh, see, that's why I don't like Mac.
Yeah, Apple's just there.
Oh, there it is. Okay, so it was open the whole time. It was just behind the screen. Okay.
Apple.
So yeah, that's Apple for you, always like tricking you. And okay. So yeah, there you can see what Lulwah was talking about. If you look at the
we still can't see your screen, I think. Oh yeah, okay.
Right.
Yeah.
Yes. So you would check that button, right, Lulwah? That's what.
Yeah, exactly. Because if you don't do that, it means you don't want them to consider it under HNC. So you just, your application is not qualified, and they will return your application. It doesn't mean you cannot do another one, but that's a very common error done by anyone who's applying to either sponsor their parents or sponsor their child, because this is where you can argue. So what's going to happen is, in this situation, they will see that your application does, maybe you don't qualify as a sponsor to sponsor the individual. They will send it to the visa office, and they will look at the arguments that you've made in terms of humanitarian and compassionate considerations. So this is something that it should not happen to anyone. But again, this is something for applications outside Canada. For inside Canada, the whole application forms are completely different.
Yeah.
So
I would think that a lot of our members are going to be looking for applications outside Canada, people who don't fit in the regular, who don't fit as the definition of a family member, right? Because we know that the principal applicant can be a brother or sister of any age, can be a parent, a grandchild, a father, mother, a child, but the accompanying family members of that principal applicant are subject to the regulations. So I think a lot of us are really interested in how we can actually create a strong application that's submitted outside of Canada, and what forms are actually included. Are there any special forms, Lulwah, that go along with the application, or we're indicating that there is additional information that the visa officer should consider when making a decision?
Yeah, by the way, before she answers, by the way, we don't have this form. I am 1344.
Yeah, it's not part of
The program is not, just to clarify.
Yeah, thanks for clarifying that, Ahmed.
But you need it if you want to apply for HNC outside Canada.
Do we need it in our program?
How does it fit in with our program?
So you're applying for HNC in Canada or outside Canada?
Outside Canada.
Assume outside Canada, yeah.
So outside Canada, you definitely need it because you're applying. So this HNC is going to append the regular application. So whatever you want to do it, you have to argue under HNC, but this form is definitely needed outside Canada.
Okay. So Lulwah, I think
for any applications, or this is for any kind of application, or is this for parents and grandparents?
No, not for parents and grandparents. For any kind of sponsorship of a family member.
Yeah, but just to clarify, I think many people here, including myself, are very much interested in our program, and I can give you an example. For example, I applied for my brother. He has 3 kids under 22, and then maybe say 2 daughters above 22. So one of them is still studying at the university. The other one just graduated. So in this case, we don't want them to come without their older daughters because she's still a student and depending on their parents, and the other one just graduated and depending on the parents. And in Sudan, culturally and religiously, all single daughters stay with their parents, and the parents are responsible for them until they get married. So many people are interested in this very specific case. So if you could maybe elaborate on here.
So yes, for sure. I mean, so just to clarify, you cannot sponsor your older brother.
Under the public policy, they are allowing siblings to be the principal applicant. So they are permitting siblings who aren't normally allowed according to the definition of.
Okay, irrespective of the age, right?
Irrespective of the age. Any age. It's those accompanying dependents that are subject to the regulation 1 subsection 3.
Okay, so then you would have to draw in your application so that you know what you're dealing with, because it becomes very complicated. So I'm sponsoring my brother from Sudan, but he's got 3 kids. 2 of them are less than 18, and one of them is 23, 24. And unless they're married, I mean, like if they're married, that would also imply other issues. And then you would have to kind of look at what are the issues that I have to address for the immigration to consider. But again, it starts with that tick mark. If it's not there, it will not go for a detailed assessment.
So you're saying there's a very strict procedure in place that when an application is made, you have to include the right form and you have to check the right box in order for that agency claim to be assessed. So it's not only you're providing, for example, a supporting letter and you're including a lot of additional information, but you have to have an actual, whether it's the IMM 1344, and you seem to say that that is the form that should be included. I think what would be very useful for the membership is that what we can do is, in addition to the forms that have to be completed right now, so for example, the schedule 0207, 0208, we can maybe create like an additional checklist related to situations where there may be an agency claim. And in that case, say for example, you'd have to include IMM 1344 in the additional forms, because there is, if you go into the PR portal, there's a section where you can add additional immigration forms. And so you're saying, Lulwah, that if Imad wanted to sponsor, his or be the anchor for his brother who has a 25-year-old daughter, then they would include in the additional forms, they would include the 1344.
Yeah, and explain why she has to come, especially if she's not married.
Yeah.
You
What
know?
is the value of the religious explanation, the religious cultural explanation?
Yeah.
One thing that the IRCC officer said last week when we met with the SCCA and IRCC, they said that one of the program objectives is equity. And this word drove me nuts. They want to make sure that there's equity in the immigration system, meaning that we can't give preferential treatment to one group of foreign nationals and not another group. So how does religion and culture, in the way that Imad described, how would that impact the decision of whether or not to approve an agency claim?
I mean, if you feel it's an issue, I would argue it in your submission. I would say, I know if this situation was happening to my son or my cousin or whatever, the application will definitely be considered. But consider the situation from her perspective, considering our religious background, our norms, our culture. So I mean, if you explain it to them, it makes it so much easier for them to accept it, to consider it, at least not accept. I mean, we are not in the officer's shoes, but
Is there recourse to an appeal, Lulwah, if we do apply? Say, for example, Imad wants to sponsor his brother and his older niece. If the immigration officer refuses that claim, is there a way that we can apply for the decision to be reviewed? Is there an appeal process for that type of decision?
I mean, yes, there is, but I would make sure, first of all, that you've addressed all the issues, the key issues in the application. And if you have, then you can go back to the, I mean, because it's overseas, you have only 60 days to file a notice to review and argue that there was a breach in this situation of procedural fairness, where we gave you all the information and you neglected to consider them. And this has an impact on so and so and so. So I would definitely, that doesn't stop them from applying another time, So whichever they find more feasible, they can do.
So, Lulwah, I have a question. So most of the people, I don't think they included that form that you're referring to right now. And they've just included their daughters in the application. And they wrote an explanation of why they're including their daughters who are over 22. So will that impact their application? Will the officer consider it without that form?
Scott, can you confirm if this is included based on the requirements of public policy?
There's very little guidance in the instructions, and of course the instructions were released the same day as the program opened on the 27th. So very little time to actually prepare for any of these contingencies. But no, there's no indication that those family members would be permitted. So the guidelines were quite clear about the principal applicant. The age requirement doesn't apply to siblings. It does apply to the family members of the principal applicants. What I'm sensing is that people went ahead anyway and made an application to sponsor older children who are above 22, and then included a letter of explanation. Maybe in some cases they probably didn't, but there was an explanation included as to why this person should overcome the regulation that they're not to be included. Now, I think the other question is, once that application has been made, can we then go back through, for example, the IRCC web form and add additional information to that file? Now, can we go back and include that form? Can we then provide compelling reasons after the fact? Is that
If
something
I were them, I would honestly do everything I have in my power, to substantiate and strengthen my application. And you know what? Even if they don't need it, they'll just say, okay. Otherwise, what my concern is that immigration just like does everything last minute. So they'll send you back another application and they say, you know what, you didn't file this application, so send it to us. So you'll be saving yourself a lot of time if you include this. But based on this presentation today, if you feel that there's something you did not address, like an argument, everyone writes an argument why they should come to Canada. I would include it in the web form. There's no other place.
Yeah, we have to go back and use the web form. And so we'll provide instructions on how to access the web form. There is going to be a special web form designation that you use for this particular public policy. You add SD 2024, I think, at the end of the web form message. But yes, and so the concern really, Lulwah, is that there was a cap of 3,250 principal applicants. And so I think people were understandably anxious and eager to get their applications submitted.
Yeah.
And many people probably thought that, okay, we'll send the applications, and then if IRCC wants more information, they'll contact us. But it's important to know that if some of the forms were not included, so for example, if you were having difficulty with the 0207, the Schedule 1, and you didn't include it, well, chances are very good that the application will be returned and you'll have to reapply.
Yeah.
I think one of the tasks that the SCCA has right now in continuing the dialogue with IRCC is trying to extend or trying to increase the cap of applications, because we don't actually know how many applications have been currently received. And in fact, I would imagine that there's been no determination yet on whether or not any application meets completeness, right? It takes a long time to get to the completeness stage. It'll take a while for the immigration officer to issue what's called an acknowledgement of receipt letter.
Yeah.
So each applicant obtains the acknowledgement of receipt letter. Usually it takes about 6 to 8 weeks after you send the application. That will signify that all the documents were included, the forms were included, the fee was paid if the fee is required. But they still haven't gone through and assessed eligibility yet. When they do assess eligibility, they may come back and say, listen, you've included information here for a family member that is not eligible, right? This family member is 26 years old. She's not considered to be an accompanying family member according to Section 1.3. And hopefully IRCC will say at that point, okay, give us more information about why you think this person. So do you think IRCC would come back and actually invite applicants to provide more information about their family member that may not be covered by the regulations?
Honestly, I wish. In cases like this, when time is of the essence, like not in Sudan's case, where, for example, a few weeks ago, we were doing a sponsorship of a dependent child, and it was just 2 days before they turned 18. So I told them, like you can put a letter, like a submission. That's what we do, and explain your situation. And if you want, if you want them to consider your application without bringing it back, you can ask for it. So even if the application is not complete, if you're asking, please do not return it or take me back to the beginning of the file. Just consider this as received and ask us for any other additional documentation. I mean, you can do that. You can do anything.
And I think from the perspective of the SCCA, so Imad and Sarah and others, in your continuing conversations with IRCC, those are two of the points that you can really emphasize and ask IRCC for some guidance and clarification and some leniency in terms of rather than sort of returning applications for those family members that may have been included, rather have them sort of ask for additional details about why they should be exempted from the requirement or from the regulation as it relates to family members. That would be the first thing. The second thing would be to put pressure on IRCC to increase the cap and give people a little bit more breathing room. And again, we don't really know how many applications have been received yet. And so it'd be interesting to find out from IRCC those 2 points.
Well,
Is there
IRCC had a meeting and they said that officers will practice flexibility in terms of the some of the requirements. They're not like there's going to be some leniency, but we don't know to what extent this leniency is going to be. But they did say that if it's not like fatal mistakes that like jeopardize the whole application, they will not be returned. And they'll give people the chance to update their information accordingly. I just want to confirm again with you, Lulwah. I don't know if we can take this offline, the form, if it's confirmed, so we can share it with the community. I just want to go through it with you because my understanding is this program has like a specific designed forms for it. So if you don't mind, we go through it. And if it's confirmed that we need to use this form, we can take it back to the community and share it with them.
Yeah, I mean, what I could say is before doing this, can you confirm with immigration? I mean, I guess you've got a one-line more conversational aspect with them, and ask them if this is required, and if yes,
Okay.
You know, I think that makes more sense.
Yeah, it's better this way. Thank you.
I think in the context of that 1344, I mean, that relates specifically to sponsoring a spouse or a common law and the eligibility of the sponsor. In this case, the sponsor and the anchor are slightly different. The eligibility criteria for the anchor in Canada, I think, is going to be viewed differently than the eligibility for a sponsor in any sort of family class application. So I'd be surprised if actually they would be looking for a 1344 form. Although it says there is a sort of the questionnaire about the sponsor, and if the sponsor doesn't meet eligibility requirements, in that case, you would continue with the application and provide H&C grounds. But I'd be very surprised if they did sort of request the 1344.
They need it for sponsorship of family members.
Yeah.
So
okay.
I can assure you.
Yeah, let's confirm that because that's going to be.
So instead we could ask even a question like if some family want to consider H&C, what's required? Well, maybe we should ask them like this. Is it?
Yes, I think we should just ask them if we need the form for the people who are above the age or who doesn't need the family definition.
Yeah.
Yeah.
The challenge there is that there isn't a set checklist for H&C. Because it's a case by case, they may not have a really clear idea of what they'll just say like include whatever evidence you think is important. So my concern is they won't actually have any additional forms. But yes, I think it's going to be important to check with IRCC and confirm.
Yeah.
So just can you also, because one of the confusing points is a dependent, what's the definition of dependent? We understand under 18, so under 22. So, but when can we consider a dependent over 22? So could you just elaborate a little bit on here?
Okay, so technically for immigration, to sponsor someone who's a dependent, unless they're less than 18 and their parents are both they've passed away, so you can they're considered a dependent, and the process is very straightforward. But if they're over 18 and less than 22, then you have to apply. I'm talking to you in a general setting. You would have to consider them under economic hardship, compelling reasons for hardship, And if they're over 22, then it becomes very hard. However, with the public policy that you're talking about, there may be a way that you can argue in the process.
Yeah. In some cases, I mean, when you're trying to make a case that there is a dependent child that's over the age of 22, you're typically, right, Lulwah, you're typically trying to show that that child is either economically dependent or mentally, right, because of a mental disability.
Yeah.
Because of a mental disability, which prevents that person from becoming economically established on their own. And so if you have like a severely autistic child who's over 22 and who has really no means of making a living on their own, they would be considered a type of dependent that would potentially be included in the context of a family application. And the other thing that Lulwah mentioned earlier is that even if the dependent is under 22, but they're married, they may not be eligible to be included as a dependent. So because again, they're not, strictly speaking, dependent on their parents anymore because they're now independent and married. So those would be some of the things to watch out for.
Yeah. And so many considerations for agency. Well, the onus is on the applicant to provide evidence that this meets the threshold for humanitarian and compassionate consideration. Now, what kind of evidence do you prove? It depends on the case. If it deals with disability, you would have to address, for example, physiotherapist or psychiatric assessment or something like that, because it's a third-party way of proving your idea. It's not just me saying, oh, my brother has a physical disability. It's from a third party that is proving this issue. So always think what third party I can provide to address the issue that I'm trying to prove to immigration. You want to add anything?
Yeah, maybe like a documented. Yeah, I think having a history of documented, like, if you're coming with a letter that was just recently issued to say, well, the child has been, clinically this or that since a very young age, it may be less compelling. But if you bring, historical documents that sort of identify the initial diagnosis, and then there's additional medical documentation that follows up that diagnosis over time, that would be a much stronger case. And so the burden, you would have satisfied perhaps the burden of proof to a higher level if you did provide more history but again, officers are not going to go looking for evidence. And so it's important for everyone who is providing any sort of evidence in the application to provide as much as they can, because the officer has no obligation to come back and clarify any information that may be missing. It's not they're not obliged to do that. It's a courtesy if they come back and say, can you clarify this point for me? But it's really up to you to provide all of that upfront, and even upfront, not relying on the web form to go back after the fact, but clearly providing all that information upfront and not leaving any question marks for the immigration officer. Because again, they're not obliged to come back and ask you for clarification.
And if they do, like you said, Scott, it's based on the kindness of their heart. But that's why I said from the beginning, I ask all my arguments in my initial letter, so that the officer, like everything that's on my mind that I want them to consider in my application, I put it there, and at least if they don't consider it, then you have an argument to make.
So we've talked about the burden of proof, which is the requirement of the applicant to provide everything the decision maker needs. The threshold of proof is a bit different. That relates to the balance of probabilities. That relates to the assessment of that information by the immigration officer. So has the information met the threshold of proof, in the sense that there is a balance of probabilities that this is in fact the case. There's a balance of probabilities that this person will experience hardship, will experience torture. There's a balance of probabilities that this child will be negatively affected if they're not reunited with this foreign national. So there are two standards of proof here. There's a balance of probabilities, and then there are reasonable grounds to believe. Do you want to discuss a little bit about the reasonable grounds to believe and maybe how this is important in the context of the HNC?
Yeah, so this goes back to criminal charges because you don't want to, you don't want to jail someone, put someone in jail for something that, balance of probabilities is just like you believe that they did this. Reasonable grounds is the other way. So we don't want to go here too much, Scott. It's confusing everyone.
Yeah.
So I know it's confusing, but the issue is, you have to consider what you're trying to provide evidence in your application. And the higher the threshold, it means that the more impact you need. And the way I see it is when it's outside Canada, there's a higher threshold to meet the requirements for HNC.
This
The
is
question for people who already submitted applications, and so can they add like information and or some HNC letter or something after they get the application file number or no?
Yeah, that's what we just discussed, right? So once
Yeah.
they get the AOR, the acknowledgement of receipt, there will be a file number, and that makes it possible to send a web form request. So there is a specific text they should include in the web form. But yeah, Lulwah, anything you want to add in terms of what should be included in the web form submission?
I would hold before sending anything because you don't want emails going back and forth. Otherwise, it'll delay and it'll confuse the officers. So I would focus what exactly you want to add and then submit it all once and for all.
And once you have the file number, right?
Yeah, for sure.
And once you have the file number, it means that you've passed the initial threshold. It means that you've passed the completeness check. So it means the forms are all included. It means that the fee has been paid. And so the application is deemed to be complete. It doesn't mean that it's been approved. It means that the application is complete. And that's where you should be adding, perhaps getting ahead of the ball, getting ahead of the officer's assessment and saying, oh, by the way, these are other factors that I neglected to add at the beginning of the application, but I would like you to consider because it is material to the outcome of the application. And there you can attach send your attachments, keeping in mind that there's a file size limit. I think that the total size is like 4 megabytes, right? It's kind of frustrating.
Yeah.
But Lulwah and Scott, I just want you to clarify with the people that because a lot of people are sending web forms right now in hoping that it will be linked to their application. So would you explain more that at this point, this cannot be updated in their application or not?
So do they have a file number?
No.
Okay, so on what basis are they sending it? They want to match it with an application. If there's no file number, how are they going to match it? It's just going to go.
It's just that people are panicking now because a lot of people made mistakes, missed things, and they're hoping. Some people are even they have old UCI from older visa application, and they're hoping that this UCI would be linked to this application. So I just want to because we don't want people to panic and do things that at this point won't help their application. So if you just clarify on that.
UCI is an individual code per everyone who's an immigrant to Canada has a UCI. So having a specific file reference number just matches. If you want to add information, you match it to the application. It's different than just having a UCI. So I would not recommend anyone sending anything right now. Just wait.
Yeah, just wait. It's hard.
Just wait.
It's difficult to wait, Lulwah. It's difficult because the application's been sent and people are like, oh my goodness, like I sent it because I had to send it because the cap was so limited. But I think it's really important for you, the association, the SCCA, in your continued discussions with IRCC to again press them for more information about how to communicate this from IRCC because people are confused. I don't think we're going to be able to provide very much insight into what you should do now that you've sent an application. Clearly, you need to wait because there isn't a file number yet. So all the web form submissions that have been sent chances are good that they're going to have, where are they going to triage them? Like I don't see or I can't envision how these web forms are going to be linked to a file that will come later. Although, so maybe get some information from IRCC concerning that.
I'm also seeing like a question about fees, application fees. So that falls into the same application where, can you submit without paying all the application fees?
You can't. And in this case, the principal applicant fee had to be paid with the application, right? So clients would have had to go in to a portal and pay the fee and then upload that to the application. So that's part of the completeness check. So all the forms that are included, the 0207, 0208, all the forms that they've asked for, plus the fees. And so if the fee payment is missing, the application is deemed incomplete and it will be returned.
Okay.
Yeah, the main question for the fees was the dependents who are over 22. What would be their fees? Would it be the 155 or would it be the 570? That was the major question from a lot of people.
There isn't really a mechanism to answer that question because those accompanying dependents are not permitted to be included in the application. So I don't know what the appropriate fee would be. I would imagine IRCC would say, okay, we accept your H&C claim. Here is the fee payment that you have to pay. I don't know. I don't think it would be 155 because that's the fee that you pay to a dependent under 22. And I don't know if it would be 575 either or 570 because that's the fee that's paid for principals and accompanying spouses. So I'm not sure. Lulwah, any idea about what type of fee would be charged for an overaged dependent?
Here it says, and I could be wrong, so don't quote me. But I would also check because from what I'm hearing, it was a mass level of application that was just thrown onto everyone, and everyone was scrambling to submit an application just to secure a spot. So I think this gives everyone room to go back and see what it is that they could have or should have added, and wait until you get the application number, and then say, okay, here is the rest of the information, because immigration is going to come and ask you. But from what I'm seeing here, sponsor your relative 22 years or older without right of permanence. It's going to be 1,080, if I'm not mistaken.
You mean for the two together? What do you mean, 1,080?
The one of the fees was waived.
Yeah, the right of PR fee is waived.
The right
Yeah,
of
the
PR
515,
was
the right of
waived.
PR.
Okay,
The
so
adult
it's just
fees are
565.
570, yeah, somehow.
570 for the adults and 155 for the children.
Yeah, also one of the confusing things, at some different links, it said 560 for a principal applicant, and somewhere else in our path it said 570. So some people followed 560 and they used 565 and paid.
Usually,
So,
if there's a discrepancy,
so
in
what
fees,
will happen to them?
they'll ask for you to pay the difference. Usually, because if you've paid the fee but it's incorrect, they'll come back and ask for the difference. They won't typically return the application. But these fees are also found in the guide. Yeah.
But what I would say, if unsure, pay more than less. If absolutely unsure.
They've already paid
Yeah, but
less.
they have submitted already. They thought it was 565 and then they paid and submitted. And then after that fact, they realized, oh, there was 570 somewhere. Because our link actually wasn't working to pay the fees, the link actually was not working. So we had to go use different ways to make payments and attach it to the application. And that's why if some people knew from our program, they calculated and they went and followed different links. And some people went to the different link and found, oh, it's 565 and they paid that 565. So another thing is, for example, somebody used, say, the fee, and then I think somehow he got applied through a different path, and then he discovered that was wrong path, and he came back and applied through the Sudan path, and they used the same fees. So they are asking me, what can they do now? What should they do now? Because
So if
both
they
applications have. Yeah, go ahead.
Sorry, can you repeat your question?
think we're
Yeah, so
diverting from
basically
the main.
somebody went and applied for a permanent residence through a different path rather than using a Sudan path. And then they realized, oh, we told them that was the wrong one, you should follow Sudan one. So they went back and reapplied through Sudan path, but they used the same payment receipt. So what will happen to their case? They're asking.
Yeah, makes sense. They can use the same payment and just say, if you have an issue with this, just come back to us before refusing our application or returning it.
No,
That's what.
both applications now have been submitted, and now they are asking me, what can we do now? Both applications have been submitted without explanation. The first one submitted because they thought it was the wrong way, right of way of doing it. And then the second one submitted and they didn't realize they had to put explanation letter or something saying that, for this one. So now they don't know what to do.
Okay, going forward, everyone who has not yet submitted an application has to read the guide, has to really read the guide carefully because the guide specifies how to pay the fees and what fees are required. So make sure that those of you who have not submitted an application, read the guide, and if you need advice, contact us and we'll provide some guidance and clarity on some of these questions. But yeah, if you have any doubts, don't send the application because you feel there's a panic because of the cap. I think it's more important that you submit the application correctly the first time rather than having to come back and having to fix mistakes, because there's no guarantee that that there is going to be a way to actually fix some of the mistakes without the application being returned. So just a word of caution for those of you who have yet to submit an application.
There's a question about, does HCC consider health conditions, like, for example, cancer or any other kind of disease?
Yeah, for sure.
Yeah, we're going to get to that. We have a few slides to cover, so maybe we can continue with the slides, look at hardship assessment, and we're also going to be considering overseas processing, country conditions, and medical treatment and access to medical treatment. So why don't we continue? Can we do that and then save the questions for the end of the presentation?
Yes.
Sure.
Go ahead.
Okay.
Thank you.
Okay, do you want me to go, Scott?
Go for it, Lulwah, yeah.
Okay, so in terms of the hardship assessment, the determination of whether there are sufficient grounds to justify granting an HSC request will generally include an assessment of hardship. So what's this assessment? Hardship continues to be an important consideration in determining whether significant humanitarian and compassionate considerations exist to justify granting an exemption and or permanent resident status. So you're going to ask for the hardship issues under the criteria that we've made reference to. It's in one of the slides. But as Scott said, make sure you're reading the guide. It can provide some information that is not very clear. And if you're not still sure, we'll do our best to explain. But it does make a big difference to know what you're dealing with from the beginning. So
yeah, go ahead. Sorry, Lulwah. Yeah.
Okay,
I think moving forward, focus on the HNC because some of the things we talk about not related, but so to save the time.
Yeah.
Okay.
Yeah.
One of the aspects is make sure that you provide sufficient evidence and you state the exemption that you're looking to overcome. The last bullet point here is important because if you do decide, like if you identify that you want to overcome this one particular regulation or this one law in the act, and the officer says, well, this isn't really material, it's not important to the assessment of HNC, but they may actually on their own look at the act and the regulations and decide there's a more appropriate exemption in place. Is that correct, Lulwah?
Unless you ask for it, you cannot get the exemption. That, unfortunately, that's the thing. So they're not that kind. Let's put it this way, in saying that you don't meet all the exemptions, but just throw this in. You have to ask for an exemption from hardship. Even if you don't have a passport, you have to ask for an exemption from a passport. You have to ask for an exemption from not meeting the requirements for immigration. All these things, even medical, even financial, all these things, you have to ask for the hardship application. The officers don't determine whether a well-founded fear of persecution, risk to life, danger to torture, and risk of cruel and unusual treatment has been established, but they may take the underlying facts into account in determining whether the applicant will face hardship if they return to their home country. So, this is if you want to use the argument, for example, fearing the immigration authorities in Sudan, if you don't submit to the serving in the army. So this is, in a way, you can use this as a risk to your life, but at the same time, you can say, well, if I'm the only person working in my house, and if I'm not there, this is what's going to happen to my kids, and just clarify on that. So
this, what we're saying here in this bullet point, is it right, Lulwah, that so officers do not determine whether this fear of risk to life has been established. So they're not looking to prove it, right? But they're looking at, on balance of probabilities, whether that would be the outcome should the application be refused. Is that a correct way of summarizing that?
Yeah.
You don't have to definitively prove the fact that you're going to be hurt, because obviously that would require you to show that you've been hurt. But instead, you're presenting a compelling case that if your H&C claim is refused and your application is not accepted, that you will face this particular cruel, unusual punishment or torture or danger. Yeah.
Yes, and that goes back to the initial question that we always include: what would happen if my application is refused? This would happen to me, so and so and so. So and you can't provide proof. If you were detained. I mean, if you were detained, of course you have to provide evidence, but that's not the only issue in the case.
And so you can provide any relevant factors when you are looking to prove or you're looking to demonstrate humanitarian and compassionate consideration. And I think it'd be a good idea, again, to do, like, for those of you who are considering submitting an application and including an H&C basis for including a family member, for example, you need to go back and look at the case law that is very similar to the situation right now in Sudan. That would be a really good place to look, because again, you want to, because it's you can include any consideration, but you also want to create a sort of like bounded set of facts, right? You want to include the facts that are going to be the most relevant to what's happening in the country right now. And so some of these considerations, or some of the factors, may include your ties to the other family members that will be approved for a PR visa. And so, the strength of that relationship, the strength of the relationship to the anchor or the sponsor in Canada. Obviously, we've discussed the best interests of any children that may be directly affected by the decision. And certainly factors in the country of origin, so in Sudan, that would certainly affect the health and well-being. And on that last point, again, not leaving it up to the immigration officer to come to that conclusion, but really arguing very clearly and specifically with specific examples. The rebel militia has taken over our neighborhood. Our house has now been used as a staging ground for this. We've had anecdotal evidence from neighbors saying that our house is no longer there. And
you can provide pictures of your house.
These painful examples are going to be necessary to strengthen the claim.
All that I understand most of you have already submitted their application. However, this is the time to enforce all the information so that when they come back to you with an application number, you send them all the relevant information addressing the hardship and addressing, if you want someone to be here sooner than later, you have to explain why. Maybe someone has kidney cancer and they're going through dialysis, stuff like that.
So I'm not sure if there's something here you want to... Sorry,
Scott. Can I just jump in on the point of providing evidence? Because the policies one of the leniency that's been provided is for females above 22. There are also males above 22 who are in like a difficult situation where they do need to be reunited with their family.
Yeah.
How can we provide evidence that they also need to be with their family because they are at risk of being trained by the militia or captured or etc. etc.
Yeah.
If I understood your question correctly, you're asking about how do you provide proof, for example, for an individual, a male individual who's subject to persecution, right? That's the
Not
question.
persecution لكن طب حقول بالعربي لأن البوليسي عند السهولة اللي ادونا لها في البوليسي دي بالنسبة
بس تعلي
للبنات
صوتك شوي.
البوليسي اللي ماخذينها في الليونة اللي ماخذينها في البوليسي بنات الأخوان أو الأخوات above 22 عشان اللي هو gender based violence and so on. بس بالنسبة للأولاد صعبة to prove that لأنه هم برضو في gender based violence عليهم في بعض الأماكن لكن في risk إنه هم
To be subjected to the same risk, right?
Yeah, لكن more so إنه training by the militia, captured, jailed and so on.
What I would say is كمان if I understood you correct يعني إذا أنت you want to prove إنه اللي حيصير مع البي أو مع الأم is gonna apply to the children, right?
Mm-hmm.
So what you can do is هلا ليكي فيك تعتمدي على articles بس credible articles that talk about these things. قصص بالجرايد that talk about these things. هلا المشكل انه بالجرايد مش حتلاقي بالانجلش سو بدك تترجميها. سو ممكن حدا يترجم لك اياها ويحط انا I'm fluent in English and French or whatever.
Certified
This is
translation.
yeah. So لتوفروا على حالكم مش ما تدفعوا مصاري زيادة عليها. So that's the only way. Honestly, يعني I don't know to what extent you can take your child to a psychiatric therapist. I don't think this is something that is accepted يمكن بمجتمعاتنا ما بعرف. You know, بس discuss these issues with them. إذا في family violence considerations إذا هن مثلا البي is violent with his kids مثلا, the mother can talk about the influence of the father on the child, and the child can talk about his influence من بيه, you know. So there's different ways of providing the same information. Again إن شاء الله أكون فهمتك مظبوط.
I think that right now, like especially with male youth that are being recruited forcibly into the militias, there are some reports, you know, put forth by the Human Rights Watch or other human rights organizations. Those reports really should be referenced in any claim that you're making as a basis for HNC. It's maybe a little bit more obvious with women and girls who are the subject of gender-based violence in conflict zones. And again, there's a lot of literature. There's a lot of media attention on that as well. So it's a matter of actually sourcing credible reports of males. You know, if it's a 25-year-old, there's a certain range of males that are being recruited into the militias. It'll be important to reference those articles and reference those news reports. And that would be a good place to start.
By the way, I'm going to send you, I always use the issues faced by the Immigration Refugee Board because these are arguments made by our own government, you know. So what's best, then use it. Refugee protection.
Also the standing committee, I'm sure the standing committee, the SIM reports, Lulwah, I'm not sure if SIM has issued anything related to the current conflict in Sudan, but those parliamentary reports, it may still be too early in the program, but certainly our ministers of parliament who go to Ottawa and submit reports to the Standing Committee for Citizenship and Immigration, some of these themes might already be present and be circulating among lawmakers. So yes, that would be a great source.
Yes. So I'm a list of claimant document. Um, but I mean,
So maybe I could just jump to this slide and just quickly explain what this means here is that
Sure.
when an immigration officer is, again, assessing H&C grounds, they're not looking to see whether those grounds are comparable to life in Canada. They're looking at the specific situation in the country of origin and whether that hardship would result if the application is not approved. This is, yeah, so this is, I think, fairly self-explanatory.
again, we're talking about two applications. So in your case, you're applying from overseas.
Yeah.
You can also apply for inside Canada, and you know, you can also. I'll leave this to the end. Okay.
Yeah. Adverse country conditions, this is really, I think, the main consideration with respect to an H&C submission is looking to see the current country conditions in Sudan. Again, the public policy was created specifically because of adverse country conditions in Sudan, but none of this in the context of an H&C application should be taken for granted. Again, pulling in like why, again, it may seem to be redundant, but again, talking about the negative impact on the, the person, including the ongoing war, instability, the widespread violence, the forcible recruitment into militias. So those specific conditions need to be highlighted. So again, the onus is on the applicant. Again, going back to the burden of proof, the onus is definitely on the applicant to show that these conditions merit exceptional treatment under an H&C framework. Part of that consideration is whether or not relocation is going to be a relevant or a likely outcome. And when we're talking about, remember, when we're talking about relocation, we're not talking about temporary relocation. So we have a lot of our members who have family members currently in Egypt or the UAE with a work visa, work authorization. This is not the same thing as being permanently reestablished somewhere. This is still a precarious temporary situation. They are giving work, maybe it's an iqama in UAE, a work permit, but this is a temporary solution. There's no pathway to permanent residency in the Gulf states, so it's not a durable solution. And so when we're looking at adverse country conditions and we're looking at whether or not, because one of the conditions for the principle is that, is there another option available? Is there another family member that can submit a PR application, like in Sweden or Norway? Is there has the UN picked up that file? Are they deemed to be a convention refugee? In that case, yes, there is an alternative pathway, and the Canadian pathway would not be open for that person. And again, that's in general. There could be specific situations that would merit H&C consideration as well. But again, relocation is one of the themes that IRCC discussed in the application criteria.
Get ready to remove.
I think this is fairly straightforward. Mitigating hardship, we've just sort of talked about that. So there really is no options right now for redress or relocation. There's a temporary relocation, but it's not a permanent solution to the ongoing crisis. And that was the last slide. Is there anything you want to say, Lulwah, about, sorry, I keep hitting the wrong button. Anything you want to say about any other hardship factors, including inability to provide medical treatment? I think these are fairly straightforward. I mean, it's an exceptional situation right now in Sudan. I don't know if some of these considerations would even be looked at. Medical treatment, redress, relocation. Relocation is valid because there may be permanent residency pathways through a refugee redetermination system. But making an application for a refugee determination is not the same thing as being granted refugee status. So even if you have a family member that made an application for refugee determination, they're still eligible under this program.
Yeah.
So I stopped sharing the screen because I don't think there's any use in showing the slides anymore. I think we can jump right to questions,
Okay.
if that's okay.
If
Is there
we
anything
have
else that you want
I just wanna, because a lot of people were asking, is the agency is only limited to the child? Because other we're considering including other family members, like for example, a spouse mom. So who would be the mother-in-law to the principal applicant.
So
Any-
I would say, sorry, Scott, go ahead.
You're the expert. I'll let you answer the question.
No, it's okay. I would say, for example, it comes down to like being around your parents or your in-laws or something. So that's important. That and you know, family unification is much very important. If you look at IRPA section, I don't know, 3 or 4, one of the definitions, it talks about the importance of family unification. So you can throw this in their face and say, listen, you know, my mother-in-law or father-in-law or whatever, he's having such difficulty issues. I mean, if there's a war, how can he move around? And if something happens to him, it's going to take me forever to get to them. Plus, you know, it depends on what you do for a living. Like if I'm in the medical field, it's impossible for me to get to them in time and help them. So it depends on, you know, again, like you just have to think about, there's no right or wrong answer. It just has to make sense.
Yeah. And it's really, again, agency is for looking for special consideration when there's a section of the act or the regulations that excludes that person from being eligible, right? So in the case of a family member that would not be eligible, it's not only children. When we're talking about the best interest of the children, we're talking about children who may be affected by that person not being approved for their PR application, right?
Yeah.
And that person, that principal person, could be the mother of the principal applicant. It could be an older sibling who's outside, you know, who's above 22. But the H&C provision relates to any aspect of the act. Usually, we're talking about medical and criminal inadmissibility. But in the case of ineligible family members, the onus is on, the burden of proof is on the applicant to show that this family member would suffer undue hardship if not considered under H&C, the H&C reasons, I guess. Does that make sense?
Yeah. Okay. Someone said, what if the family is granted refugee status? So that's a durable solution, whether it's a refugee or humanitarian. So it means if they have another option to come to Canada, then there's no need for them to do anything else.
And they
So
wouldn't be eligible under this policy. So
yeah,
you would
yeah,
be eligible to sponsor them under the temporary public policy. Yeah.
yeah.
They will not.
So
If they're already a refugee, if they're deemed to be a convention refugee somewhere, that means they have a pathway to permanent residency. It means that they would not be eligible for the program. As far as
yeah,
my reading of the instructions and what IRCC was saying is that
yeah,
if there is a viable PR pathway, then this program would not be for them.
exactly. Yeah. So they have a durable solution. So that's it, you know. So what's their solution? And it could be to another country, not necessarily Canada.
Right.
But
Canada
but
works with partners, right? The idea is to
sorry?
find a solution for that person. It's not necessarily in Canada.
Yeah, yeah,
Canada would work with partners to find a durable solution to that individual.
yeah. And we've had situations where, you know, you've seen people say, no, I just want to go to Canada because that's where all my family is. I mean, if they want to go that route, it's just going to delay the process. But if they're going to the US, they can get their citizenship and eventually come and visit here. Um, you know, so again, just use your common logic and in the application. Uh, but I see that they're offering a lot of leeways for the application.
So some exemptions. But
Yeah,
again,
yeah,
right now, the exemptions are not for these extended family members, right? So the principal applicants, yes, exemptions in place. for accompanying family, accompanying dependents, there's been no exemption identified in the instructions in the guide.
Okay.
So I think that's going to be the real the heart of any agency claim going forward, is to include people who are not actually eligible under R1 subsection 3.
Yes, exactly. So, okay, I'll get to some questions, but
Okay,
we want to have
before we
somebody
do
from the
that,
SCCA. Can we moderate those questions? Maybe there
yeah,
was a question.
I'm here. I have a few people who have had their hand up since the beginning. So I have iPhone 22. Sorry, iPhone 2. I'm gonna ask you to unmute.
your voice is very low, right?
Can you either, so Mr. iPhone, can you or Mrs. iPhone, I'm not sure, can you either text the question or unmute yourself? And everyone else, if you could put yourselves on mute, there's kids in the background and it's sort of interfering with the volume. iPhone?
iPhone 2?
So, so I think it's me. I am not sure, however. So I hope my question is along the line with the purpose of this session. My question is actually triggered by the suffering I see people experience to navigate through the system to make their applications. So my question is about the relationship between an applicant and an immigration consultant or immigration lawyer. In another word, I mean, first of all, I understand the importance of people educating themselves about the issue. Here being the HNC issue. So, what I am saying is, if I hire a consultant or a lawyer, how would that make my life easy and do an accurate job to submit my applications? Thank you.
Well, I think what we've been seeing, and I'll also allow Lulwah to pitch in here, but I think what we've been seeing up to this point is some confusion around the requirements and the eligibility, interpreting the guide. So I think having a consultant or a friend or somebody, a lawyer, who has experience in interpreting the language of our immigration authorities is important. Knowing where to go to pay the fee is important. Knowing how to validate a form or filling out a form to minimize delays is a big deal. We don't, so maybe a misconception that I would like to clarify is that we don't provide, obviously, guarantees for an outcome, because the decision is always up to the immigration officer when reviewing the application. I think the value added of having an authorized, and I want to underline here the word authorized, representative, is that you're going to be minimizing delays and ensuring that your application is complete based on the experience that we have navigating either this program or similar immigration programs. The issue there is affordability for a lot of people, and that's something that you discuss on an individual case-by-case basis with your immigration representative. So if there are sensitivities around hiring somebody, and those sensitivities tend to be financial, then it's worth discussing those issues with the rep. And some will be much more amenable to providing accessible services and providing a payment schedule. But I think there's a lot of value actually in appointing somebody who knows what they're doing. And when I say underlying authorized rep, it's important you hire somebody that is licensed by our college, because both Lulwah and Lulwah went the further step and became a lawyer and has legal training in addition to specific training in IRPA and regulations. I myself am not a lawyer. I have extensive experience reading and interpreting the Act. And so you have two very qualified representatives here. So I would say that if you do go and look for someone, that you ensure that they're qualified and they're licensed to actually represent you. That's what I would say. Lulwah, do you want to add something about the value of representation?
I would say
It's my heart, definitely.
no. I mean, I would say look on like as the college for consultants. Our name is on the website, so you just go and you see if we're licensed, whether it's us or someone else. Because a lot of people are claiming that they're licensed and they're not. So that's very serious, and this falls on you. I mean, I wish there's another way of saying it, but it falls on you. You have to do your research. Even for lawyers, their names fall under the I'm not sure which. I think it's the NCA or Law Society of the province that they're in, and you can see if they're licensed or not, or if they're on suspension for whatever reason. So it's important, again, for you to contact to do your research in advance.
The other thing I'll say too is that a lot of this stuff is time sensitive, right? So, if IRCC sends a request, sometimes they want a response within 7 days, sometimes within 30 days. And if you're busy with your life, I mean, this is the work that we do exclusively, right? So, to have somebody who's designated and who's licensed and authorized and also competent, you also want some help, some professional help from people who are ethically minded. We are regulated by a code of conduct and professional standards, so we have to adhere to a particular code of conduct and the standard of professional conduct. So I think there's a lot to be gained from retaining not only licensed professionals but competent and ethical ones too.
Yeah, I can't say anymore.
Okay. I have the next person is Abuzar. Can I ask you to unmute yourself, Abuzar?
تفضل أبو زهر.
ممكن تسأل سؤالك.
Are you guys hearing me?
Yep.
Okay. So just very quick, 2 questions. The first is, sorry, my questions are on the application that I have already submitted. It's not about the HNC, if that's okay.
Yeah, sure.
Yeah. So it's just that I have submitted 2 applications. The first one, the proof of relationship between me as an anchor and the main applicant, supposed to be our national ID. And for me, I just submitted the translation. I forgot to upload the original Arabic documents, although the main applicant already submitted the full document that shows the translation and the original documents. So, and the other issue is on the declaration form. I am a Canadian citizen, so I didn't add my UCI, but I did add my Canadian identity. So in this case, so are these 2 cases would consider my application incomplete to the point where I should reapply, or it's not that risky and I should just prefer to wait and hear from them at the point of receiving an AOR? And if it's incomplete, lastly,
so I think
is it okay to upload a web form using, I know you guys already touched on that, but just applying a web form, adding SD24 and attaching the correct ones?
So I think maybe I can answer the question because I've been through the application process already. And as long as you don't need to provide a UCI number for yourself. And even the UCI number is usually optional. If you know it, the principal applicant would include the UCI if they know it. As long as, because there is an attachment for proof of status in Canada for the anchor. So there is where you would have had to upload a copy of your passport or other documents, PR card, front and back, indicating your status in Canada. As long as you did that, as far as the translation goes, it sounds like you may have already attached the translation and the original in one of the attachments, but you're saying that for the specific attachment, it was only the translated one? Is there another area in the application where that information has already been communicated or no?
No, so for me as an anchor, I just uploaded the translation. I should have combined the PDF with the original Arabic document.
Sure.
Which I didn't. But for the main applicant, he uploaded the full document. And just to add the point, I translated my national ID here in Canada, where the translator has an address and phone number. So
Your national ID, what do you mean? Your
So
own Sudanese national ID?
Sudanese.
yes, to show proof between me and my brother, who will be the main applicant, I needed to show proof of relationship, which usually in Sudan is our national ID.
Yeah,
So I didn't upload the document, Arabic document. I just uploaded the translation.
Yeah, I mean, but you're saying the applicant uploaded the original plus the translation of whatever document they had to upload?
For him, yes, he did upload his national ID that shows our shared mother name.
Yeah.
And he uploaded the translation plus the original document for him. But for me, I didn't upload my national ID, original Arabic document.
So the documents that would have had to suffice for a complete application would be like police clearance checks. So if you uploaded, the original without a translation, that may be an issue. They would likely come back and say, give us another police check if you've already uploaded it in good faith, and you've uploaded the forms, you've uploaded the fee payment. It sounds like the application would be complete and you would be given an acknowledgement of receipt letter with a file number. In that case, I would go back and just clarify the fact that, yes, you are now combining the original with the translation in case, and you just want to let them know in case they have difficulty finding that document. We can't assume that there are people who speak Arabic in this program. I would like to assume that there are people who are processing these applications who do have Arabic language, capabilities. I like to hope so, but the reality is that every document that's submitted to IRCC has to be translated, and translated by a proper translator and not yourself, right? So it's important for everybody here that you're not translating your own documents. You're getting somebody who's a certified, whether it's in Canada or overseas, that person has to be a certified translator.
Sorry, I don't want to take more space. It was just one of the main corners for the program, that me as an anchor to have an immediate family from Sudan, and I was just worried that I didn't submit the original Arabic document. But thank you. That's really clarified.
But just to clarify, also, Scott, just to add to what you said, you have to upload the original language plus the translation, not just one of them. They did both of them.
So this is my mistake. So I just uploaded the translation. That's why I was a bit worried.
And that's why we're saying, hold on to everything that you are discovering that, you should have done. And once you get the file number, tell them, I've discovered that I did this. So please take this.
I was just worried that based on this mistake, there won't be an AOR at the beginning and it will return to me as an incomplete. So from your experience, do you think this mistake would make the application incomplete or just in need of further, correspondence based on the condition for the program, which shows you have a sibling in Canada?
My sense of this is that it's not going to put the application, it's not going to send it back, because, well, first of all, it's if it was a security clearance, if it was a police clearance and that was missing, the risk there is that it would be returned because that's a core document that has to be uploaded up front. And the second reason why I think you'll get the AOR letter is because the officers who are dealing with this program do have leniency in mind, right? They're not there to identify flaws in an application to get rid of them. The idea is that they're going to be working with the SCCA, they're working with individual anchors and principal applicants, because it is a humanitarian program. So my sense is that there's going to be leniency with these documents, not necessarily the security clearances or forms that have not been uploaded or fees that have not been paid, but minor corrections. And in your situation, I believe you'll get the AOR letter with the file number, in which case go back and just upload it again, just for the sake.
Okay, lastly, if we send an explanation letter for the absence of police clearance and we told them that it's in the process and we just received it a few days after the submittal, we discussed already, you guys discussed the issue of sending a web form now, but just waiting the risk of returning the application, do you think it would be a good idea to send the web form with the recently received?
No, because you've already provided an explanation. You've already provided proof that the application's been sent or that the police clearance report has been requested, right? So
Yes.
IRTC, the officer knows that that request has been made, and they'll look for it. Either they'll request it, or they'll see that you've added it in the as a web form submission. So if you've provided an explanation, I doubt they're going to be returning the application. Instead, they'll be looking for that document to
Okay,
be added.
thank you.
Thank you.
Thank you, Abu Zar. Can I just remind everybody that we're like الزمن مشي شديد ودايرين نحاول نغطي أكثر في الأسئلة أو الفورمات as you Scott and Lulwah, if you don't mind. But Muna has had her hand up since the beginning. And can I ask you to unmute yourself, Muna? Muna?
Yeah. Hi. I have a question. Sorry, I'm going to be talking for my mom. So she has a cousin right now. He used to work in the military, and because this is under compassionate humanitarian grounds, we're wondering if we can do it for a cousin. So her cousin, they came, like the rapid military forces, they came to Khartoum looking for them. They burnt both the house, his house, and his mom and dad's house. They started looking for them. حولناهم للشمالية, and now they came looking for them there, and their life is just kind of in danger. The kids, him, his mom, his dad, and this is my mom's cousin. We're just wondering if under humanitarian grounds we can apply for the cousin and my mom be the applicant anchor.
Yeah, because the cousin's not, Lulwah, I'll give you this answer, but right away, the cousin is not somebody who's described in the act or the regulations. So you would be looking for an exemption to that, right? So that would be the Lulwah?
Yeah,
So
I agree.
So we'd look for an exemption to that, right?
An exemption for not meeting the public policy requirements based on the factors that, you know, so and so and so, you're asking for exemptions. But this application that you're talking about, it's more complicated. It's not just a public policy where you can just go ahead and complete the forms. This is going to fall under a sponsorship of her brother, although she knows she's not going to qualify. But that's where we talk about, we want to increase the chances of the application being approved. So not necessarily the fact that she's not meeting the public policy. You're asking for an exemption.
Yeah, because when I joined this, I was like, okay, under humanitarian grounds, we asked for exemption of that. He's not a brother, he's a cousin. We have pictures like where they came, like the house is burnt. The neighbors have sent everything to us. Right now, they came last night actually looking for them, and then they like the people who they were like up north, where they came asking for them. They filed police reports, so we have that there. We are relocating them to a different area right now, but again, it's still within Sudan, and these people are obviously knowing like where they're going. They're like tracking their every move, right? So we're trying to do like a humanitarian base under, he doesn't meet the condition of a brother, sister, spouse, you know, all that, but as a cousin, given the situation that they are, and there are young children involved.
Yeah, and you have to
like
explain
his mom is my mom's cousin, like my mom's aunt, her Amata.
Okay. I mean, still, it doesn't fall under the public policy, but otherwise, everyone will sponsor all their family members. You know,
Yeah,
that's the case.
Second cousins, yeah, you can extend that. I mean, you know, to quite an extended family, right? I think the weaker the family link, like the further away you are from immediate family, the more difficult it's going to be to substantiate some of these claims. Would you say, Lulwah?
Yes, exactly, because the ties have become very weak, and especially if you have not been in contact with your family members for so long, these ties that you're asking about, compelling reasons and all that, even the best interest of the child, become very weak. You know.
Okay.
I mean, the bottom line is do everything you can, right?
Okay.
Yeah.
All right.
Make sure that he finds like some place of safety or refuge, right?
Yeah.
Sudan. Make sure that
Yeah.
he's able to get, like, there has to be a plan B. Like, outside of this sort of immigration access to permanent residency pathways,
Mhm.
he needs to find a parallel place to go to get refuge and safety. I mean, that seems to be.
And in this situation, I would recommend, like I said before, since HNC is not a solution,
Mhm.
think of maybe them going to Egypt, for example, or a
Yeah.
neighboring country, and apply through ASA to sponsor them as refugees. I would say, you need a reasonable solution.
Yeah.
Okay. And then another question, just really quick. Is it like the way that they're picking the application? Is it by order of who sent in the applications first, or how?
Yeah. Yeah. So it's
You did
served.
You did it through the portal, right?
Correct.
And we don't know where it's going to be processed. That's why the language issue is very important, because we don't know where the application is going to be processed. It could be processed in Sudan, in Egypt, where people, officers
Mhm.
can speak Arabic, or it could be processed in Warsaw or London. You never know.
Yeah.
So
But
you have to
yes.
be.
Is it first come, like the first like applications as they come in? Those are the ones going to be processed first, or no?
Yeah, they have to be complete applications. So they have
Complete applications.
they have either a cap of 3,250 currently. I mean, there are probably discussions about expanding that cap,
Yeah.
or a 1 year. So the policy is effective for 1 year or until they
Mhm.
reach the cap. But they only count towards the cap those applications that pass the initial completeness check. Right.
And we don't know if they have reached a cap yet. Is that correct? I just want to
We
confirm.
don't know. We don't have any real-time data on how many applications have been. Right now, no applications have passed completeness check because it's only been a week. plus
Okay.
time.
Okay.
So
Thank you.
officers have not had a chance yet to verify any of the any. And I would expect it'll take like 4 to 8 weeks. I earlier said 6 to 8 weeks before
Mhm.
any of those first applications will get an acknowledgement of receipt letter. I think it's gonna be a while.
Okay. Can we move on to the next question بس يا شباب عشان الزمن ممكن نختصر أسئلتكم لسؤال واحد لأنه الزمن بيجي ضايق.
Yeah, thanks.
أوزي ممكن أقول لك ممكن تعملي ميوت بليز.
Hello?
أيوه.
Do you hear me?
Yes, we hear you.
Okay, thank you so much. I want to be very straightforward and clear in my question. My question is, I have two questions. The first question is regarding the statutory declaration. I have filled out 4 statutory declaration, IMM 0208. However, in section J, I have added 1 family member beside the anchor. This total number of the family member, which is 2. I had to money in the trust fund account. Can I share my screen, please, so I can navigate with you quickly?
I think what you're describing is pretty clear. Is that you've indicated a number of family members that correspond to option A, but you're actually submitting proof of funds under option B.
Option C. So
Combination.
yeah, option C, which is like I did 4 interest account. I put 10,000 in each one of these 4, $10,000, and then in the statutory declaration, I did 4 statutory declarations
Corresponding to each principal.
1 family member beside the anchor.
Right.
Exactly. Is that correct, or I have to redo my application from the beginning?
Well, yeah, it's hard to say indeed if we don't actually look at the application. I don't know that we have the time or the space right now to actually look in detail at the form, but this is something that a lot of people are struggling with in terms of declaring how many family members in that column on that page for the stat declaration. If you are going for option C, what you're doing is depending on your family members, in addition to the total number of family members that you're sponsoring, in the context of that application, there has to be sufficient funds from your notice of assessment from last year. And if there's a shortage, there has to be the balance that shows up in an in-trust account. Now, the in-trust account, you should have separate in-trust accounts for each principal applicant. So if you have 4 in-trust accounts and are you doing option C for everyone?
Yeah,
So
absolutely.
they're looking at your notice of assessment for last year, and
Yep.
they're taking into consideration your own family size. Now, they're not taking into consideration your family size when you're pursuing option B. If it's only option B and you're depositing money into an in-trust account, it's not about your family size anymore. It's about how much money you're making available to the principal applicants and their families. If you're combining both the in-trust and the option A, which is the basis of your notice of assessment, then they will look at the size of your family. I don't know like whether it really matters that you've indicated, because you have to provide proof of your family members, right? So if you're going with option A, you'll provide a copy of your marriage certificate, you'll provide a copy of the birth certificates of your kids to show that this is the size of your family. And when they're looking at the principal applicants that you've undertaken to anchor, they'll look at the size of those family members as well. So if there's a number that doesn't add up in one of the columns, I don't think it's going to scuttle the application. It's not going to make them return the application. There may be some, I mean, they'll look through the financial documents to see whether or not the combination of funds that you've demonstrated is going to be sufficient for the amount of people that you're looking to anchor.
Okay. Okay, that's noted because I added my CRA assessment plus the interest fund statements as well.
Yeah, because the interest funds will make up for whatever's missing from your salary from last year, right?
Okay, okay, okay. All right. The last question I do.
Yeah.
The last question I do have.
معلش أقاطعك لأنه في أسئلة كثيرة والزمن ضايق شديد.
Yeah, I think any follow-up questions you should email them, and then they'll come to Lulwah and I.
Okay.
We can deal with those additional questions. Let's take one because we have
Okay.
literally minutes left, and so
How are you doing in time, Scott?
Okay,
we'll
thank you
get
so much. Appreciate it. Merci.
another 12 minutes till 4:30 Eastern time, if that's okay. And then any sort of questions that are left outstanding, we can certainly compile them, send them to the SCCA, and then they'll send them to us, and we'll be happy to follow up with those answers as well.
Okay, and I think you and Lulwah provided your emails for questions.
Yeah.
Okay.
Yeah.
Okay, رزان واخونا اذكركم سؤال واحد بس. رزان ممكن تعملي unmute?
Hello, can you guys hear me?
Yeah.
Yeah, sorry. So I just have a quick question, if you don't mind. I'm speaking on behalf of my mother, by the way. So we applied for the application before yesterday, and for the supporting documents or evidence, I haven't mentioned any like medical reports for both my grandma and my aunt. So that I thought would deem helpful for the case. So is there a way, like when I apply for the web form, is there a way I can add those information along with whatever is required on the web form, for instance, or?
The medicals are going to be requested after the fact. So we're going to get you're going to get letters requesting medical examinations. No medical information needs to be uploaded until it's requested by IRCC.
Absolutely. Okay, so there would be a point in time where they would request that information, and where there would be a designated web form for that, where I can apply for that, or I mean, add those information along.
Yeah, it won't be a web form. It's actually going to be like they'll have to go and visit a designated clinic and do their medical exams, and those medical exams are going to be communicated directly to IRCC. So you're not going to have to provide anything in the web form unless there's additional information that you need to provide after the fact. But those medical results are sent directly to IRCC through the designated medical clinics that they've identified.
Absolutely. So then the IRCC are going to request a designated clinic where they'd have to go to, right? But let's say we do have the current medical records. Are we able to just add it without them having to go to that clinic and retest?
Unless there's a specific situation that prevents your family members from accessing one of the designated clinics, and there's no way for them to communicate any sort of medical examination, because the medical examination, unless there's an exemption found in the policy, and I don't remember there being an exemption, I'll have to look again, but the medical examination will be the data from the reports that are provided by the designated clinic will be what IRCC is looking for. So don't send medical reports because it may not be what IRCC needs, and it would just be sort of, you'd be sending confidential information for no reason. So I would wait for that medical
Okay,
instruction.
absolutely. Okay, that makes a lot of sense. Thanks a lot. Appreciate it.
Okay, shukran. Marwa? Everybody else can unmute yourself.
Hi, thank you. Sorry, I just have a similar question like Abuzer. I just submit my application, but I just make messed up. I mean, I switch some pages in the scanning stage. I mean, processing. I just mix the one of the form. The last page of the form 0207, I mixed up with with form 5476. Is that considered as a valid reason? I mean, to retain back my application, and I will use my spot.
The 0207 is one of the required forms. So if anything is missing from that form, so if you scanned in pages that don't belong to the 0207, but you have the 0207 information, like if those pages are scanned somewhere else, and the officer is able to see, oh, there's page 3 and 4, oh, here's page 1 and 2, then I don't think it's a problem because all those pages are included somewhere. It's going to be a real headache for the officer, and it might put him in a bad mood. But I don't think it's going to actually result in the application coming back unless that form is missing.
And what about the form 0208? If I misspell, I mean, because I use the same template for 4 application, so I just made a mistake in the lower page. I mean the lower area on page 4, where I have to put the principal applicant name, full name, and then the anchor signature. I just forget to raise this information and write the right person. So it's gonna be considered as a major mistake. I mean, it could be cancel this. I mean, retain my the whole application back or no?
I mean, if the form isn't completed correctly and there's minor mistakes, I don't suppose the application will be returned. If it's not, if it hasn't been signed in the presence of a notary public or someone who has the ability to swear the form, because it does require someone to swear that form. Then I would imagine they're going to be sending it back if it's not sworn and signed. But then again, we don't actually know because this is it's a special policy, and the underlying sort of rationale behind this policy is humanitarian and compassionate grounds, and so they may give people a lot of leeway in terms of resubmitting documents that are either inaccurate or missing information. So unfortunately, a lot of stuff that we're asking now, we have to sort of wait and see, because I don't think, I mean, we don't have an answer, but I don't think IRCC has an answer either.
Okay, I appreciate it. Thank you.
Raised hands.
Yeah, I just want to, Scott and all the people here, I want to clarify that IRCC is going to accept minor mistakes, so people should not be asking this type of questions. If you let a big mistake on the form here and there, they will be accepting them. As long as you paid your fees and you submitted all the forms, you are good.
Yeah, that's good to know, Ahmed. Thanks for that, because I think you guys, the SCCA, you're going to be in a really good position, even better than Lulwah and I, to get updates from IRCC in terms of what they're seeing, what they're processing. You guys are going to be communicating to them as well the concerns of the membership, and we've already had several meetings with IRCC where you've been able to communicate some of these questions and some of these anxieties. And so IRCC has returned and said, more or less, don't worry, as long as, like you said, Ahmed, as long as the fees are paid, the forms are completed to your best, then they're going to give you the benefit of the doubt. And they may ask for clarification at some point, but the likelihood of them returning an application, especially with a cap, and given the situation, unless it's a really thing that's completely missing from the application package, I think is minimal.
Okay, I just want to also clarify that your MP, Member of Parliament, is also your person to go to. Hopefully they are as helpful as they should be, because the last time I needed to reach out to my MP, they said, you can only do that through your constituent's MP. so that doesn't help. But they're there to give you answers. You've elected them to give you answers. So, you know,
Yeah.
I'm just saying.
Yeah, thank you for highlighting that, Lulwah. This is actually what we need the people to do. Like, we need the people to actually raise their complaints to MPs, raise the technical issues they're faced to IRCC, so IRC can acknowledge that there is issues involved with the application process, and they raise their issues to the MP, so MPs can direct their complaints to IRCC. There should be some noise made, so these issues could be addressed differently, and officers actually practice this flexibility which IRCC promised.
Yes, and you just have to be persistent, because immigration does not listen from the first time. I mean, you want to see what's happening. You just have to keep asking and asking. And as an organization, you have many votes. If you have just one letter drafted in the name of the organization with so many signatures and you submit, I mean, you can achieve a lot.
True.
We have a question here more related to the HSC. For an over 22 years old male or female dependent, to say having a proof of their studentship IMM 1344 form and explaining their case and how they will have no place to go is enough for the application?
Sorry, I didn't hear the question.
Okay.
The grounds for H&C, having nowhere else to go, is that what you're saying?
Yeah, they're over 22, male or female dependents, and the question is, would having a proof of their studentship IM 1344 form and explaining their case and how they will have no place to go is enough for the application?
So what I would say, if I understood your question, what to do for someone who's over 22? You're completely silent now.
I'm gonna type it up for you here so you
Okay.
can hear it.
It could be a question that we want to follow up with by email as well. It sounds like it's a case specific question, and again, the most important thing for the person who's putting together an H&C application is to gather as much compelling evidence as possible. So if the relocation is the only aspect that is that might be compelling, then it may be lacking. I don't know, but as much compelling and documented evidence as you can gather for any H&C claim, definitely.
I would say for your question, this is one argument that you can make among many other arguments.
Yeah.
Okay, I think we have 1 minute left. What we wanted you guys to touch on the forms 0207 and 0208. Do you think you can spare that time?
Can you raise your voice, please?
We have a few questions about the 0208, and I understand that our time is up. But I was just wondering if you can touch on those two forms, because they're the ones with the most challenges.
Yeah, okay. I'll leave that to you.
I really think the 0207, 0208 stuff should be like, if you can collect the main themes that people are having difficulties with and send them to us. Lulwah, I don't think you have any experience with those two forms specifically, but one of them relates to completing the signature electronically, which I think is an issue. But maybe we can just
that should have been fixed by now, because there was a glitch on the form, and it's been fixed. It should have been.
Yeah, I think we may have more questions related to those forms, which I don't really have more answers to. So I don't know, it would be really worthwhile going into details about the 0207, 0208. But certainly by email, if you can collect those questions by email and send them to us, we can take a bit more time and answer. Is that okay? Considering we're out of time, is there any specific questions related to H&C that we'd like?
يا شباب إذا في سؤال عنده سؤال عن ال HSC, please keep your hand up والباقي نزل يدينكم عشان نقدر نعرف.
There's someone with iPhone and he's trying to reach us, and we're not listening to him, and his hand is up.
Poor guy's
So
been
maybe
waiting
he can.
for the past 10
We have
minutes.
7 hands up. iPhone ممكن تعمل unmute.
No, the one who's in the looks like he's in a car and looks like he's really trying to communicate.
Yeah, I just tried to hand, but yeah, I'm okay. So can I have a chance, please?
Go ahead.
Yeah, well, thank you for organizing for, my name is Abdullah Wahid. I am representative of United Sudan International Council. In order for emergency, Sudan situation is worse. I know well Canada government proposed the refugees for the Sudan, 6 million Sudanese refugees right now in the border for Chad. And we also appreciate for Mark Miller for immigration citizenship and all the Sudanese, especially like if you compare for Ukrainian Sudanese, is almost similar. The Sudanese, we have a lot of problem. Let me finish, please. We have a lot of problem because there is no communication. The old regime, they cut people, they want to get it out. So my direct question is, some people, they don't have enough income to bring the family. But we have a United Sudan International Council in order to help the Sudanese to get out in the regime, because all is still people anti-virus is killing the people. So the Canada government opened the door for us. We would like you can help the Sudanese the way people, they have children, women in the border. That's why we wrote letter emergency for our Prime Minister Stephen Harper, including Premier Dennis Smitt here. So already accepted, and we need your help also to families a lot.
Okay, so first of all, we don't work for the government. So we're here representing our professional community, and we're here trying to discuss some of the aspects of the case, and certainly some of the humanitarian and compassionate elements of an immigration application. Any sort of policy sort of advice or recommendations that you have should be channeled directly to the SCCA, because they're the ones who are in contact with IRCC. So you can send an email directly to the SCCA and describe how, and perhaps some points that we should bring up with IRCC.
Yeah, thank you, Scott and Lulwah. I think due to the time we have to end and collect all the questions. You guys can email us at SCCA or send you questions, and we can definitely answer them.
Thanks very much, Imad. Thank you.
في الإيميلات حقت لولوا وسكوت في الشات. ممكن تشيلوها سريع قبل ما
Scott has them at the beginning of the PowerPoint. So in case you lost them, they're at the beginning of the PowerPoint.
Scott,
yeah, maybe Scott could
your
put
screen again, and then you can screenshot that.
Yep, for sure. Just a second.
نعتذر عن البادين. الله شديد قدرنا نجاوب كل الأسئلة. لكن again لو في أي سؤال ممكن ترسليهم في
But like Scott mentioned, the 0207 and 0208, I don't have experience in it. Anything else I can answer.
Okay, guys.
Thank you.
Thank
you, Scott and Lulwah, for your time.
Yeah, thank you very much, Scott and Lulwah, and we appreciate your help during this difficult time for our community. And certainly we will be answering all the questions.
Yeah, it's going to be certainly my pleasure to continue working with the SCCA and being here as a trusted resource for anyone who needs any assistance. And I'm sure Lulwah will be able to answer some questions and provide some guidance as well. So thanks very much for having us today. It's good to connect with everyone again.
Thank you.
Thank you.
Thank you.